You're welcome back. This is Newsfile, it's your most authoritative news analysis show. And here's this comment from Kofi Louis Boaki. He says, here in Belgium, we both have military and police presence in all vantage points. And that is what I expect of Ghana as well as the alerts come in. Now, Farid Shamsuddin says that the U.S. Embassy has set the record straight as to whether Nana Akufo-Addo was consulted or not before transferring these Gitmo 2 guys. In fact, this disclosure has added a lot of value and cured the mischief in the public domain. At this point, discerning observers know who is withholding information for reasons of political expediency. Ghanaians are wide awake now and more than ever before. And this is from Frederick. He says, on the authority of the bus branding judgment, okay, we'll get to bus branding. Another one here from Musa Mukaz says, I think the government and the U.S. Embassy enriched our unity and good governance by informing or consulting Nana Addo. I don't think this has ever been done in our recent history. And then Kasim in Kumasi says, it is argued that after the 9/11, the U.S. has concentrated on a new foreign policy which is aimed at spreading the threat of terrorism to across the world. Unfortunately, many countries, including Ghana, have fallen into the U.S. trap of using formal and informal alliances as the best approach to achieve its policy. I mean, this is really serious, weird. And then Kwesi Hayford in Alajo says, what at all is this back and forth Gitmo issue? The people are already here and are not creating any problem. So why don't we focus on the more critical issues like the threat posed by the real terrorist? Okay, I would have liked to have your message on the real threats, which is what we have discussed as a major issue. Thanks very much. Now, let's go to the courtroom. And Justice Anthony Yaboa, he is a judge who sits in the Human Rights Court 2 and gave a judgment that has been hailed by all well-meaning citizens all of the week as a very good thing for the democracy of this country. Citizen Ghana Movement, led by Kofi Bento and I think Nanewa or so, were in court battling a matter on behalf of some of their members who were the applicants in that case. There were 6 or 7 of them. And then they put an application before the court that they were seeking information to have access to the contract documents regarding the bus branding saga. And in the process, the Attorney General was against it. And then the court gave a ruling. And the ruling was to the effect that the state is being compelled to provide them the information that they seek. Now, a lot have hailed that judgment as a very good thing to happen to the country. The individuals who were in that case are Lolan Sego Moses, Kathleen Ade, Francis Kennedy Oklu, Evans Amegashi, Yao Bafo Ankoma, Kwame Bakers Ansa, and Michael Ano. And then the case was against the Ministry of the Minister of Transport and the Attorney General. Of course, the Attorney General as a nominal defendant in these matters. Now, when you heard of this judgment, did it come to you as any surprise?
No, not at all. Let me say no, because it's obvious that the judgment will go one way or the other. That's the normal tradition. If anybody went to court and asked for reliefs, either those reliefs are granted or those reliefs are shut down or refused. To the extent that the judge in the Human Rights Court says that citizens can have access to some information that they wanted from the state.
Right.
Will be the judge's interpretation of the operationalization of the constitutional provision that a right to information, for instance, that so to that extent, and to the extent that we haven't had an indication of an appeal yet or anything like that. If he stays, it means that, well, the judge has given a ruling and that is the direction that we must go.
You're thinking there's a possibility of an appeal?
Why not? There's a possibility. Once the Attorney General, my understanding is that they opposed.
Yes, they were opposed.
Yes, so if they were opposed and if they feel strongly that indeed the judge erred in his judgment, then they have a right to an appeal.
What do you think? The judgment is now, the court is functus official. We can discuss it. We can do anything we want to do with it. So tell me.
You see, that is why I said that the end result is what doesn't surprise me, because all our efforts anyway is geared towards the achievement of this. When we are talking about the right to information bill.
Yeah.
And in that bill, it's also the right to go to court to demand for information. And the court would have granted you the right or not, whether you are entitled or not. To the extent that the court thinks that it's not security in terms of national security or any other thing, the court would say that you should be given that information. So, well, this is a pointer to what we are likely to achieve with the right to information. So I don't see. I think that it's a good thing that people have gone to court, and I, as a lawyer first and foremost, and as a citizen of Ghana, I'm one of those who think that as many people as possible should be going to court to test our laws. It makes our constitution better. It makes our legal regime better. So really, take it or leave it. I think that the judge has given his ruling on the matter. And
there's a part of the judgment which I quoted yesterday, and I love to look at again. The judge says that it is not the law that in the absence of a freedom of information legislation, a person in Ghana is bereft of the right to information. In Ghana, every person, including journalists, is entitled to a human and constitutional right to information, even in the absence of federal legislation. Egbert, and I bring you in here, and it's instructive because you are also in court with a similar suit on the same bus branding matter. In fact, and I make the reference that in this case they were seeking basically 3 reliefs, which were just about asking for the contract documents and other related documents to be made available to them. In your case, for example, you have about 7 reliefs you are seeking, and I realize that in your relief 2, you have about a dozen questions that you want the minister to answer, which will even give us a lot more if you are successful with that suit. Now, for you, what does this judgment represent?
Well, I think that this judgment is groundbreaking, and I must commend the Citizen Ghana and, of course, the individuals who, let's say, maintain the action, brought and maintain the action. Samson, in all of these things, let me say that, our friend and senior Isan Kuma has always maintained that in the light of Article 41 of the 1992 Constitution, maybe, but for the fact that we need regulations to guide us when we are going for information, the Right to Information Bill is not even necessary.
More particularly 21.
Yes.
Article 21.
Yes. So, for example, I mean, my Lord Justice Yabwa, on the invitation of Citizen Ghana, apart from other considerations, relied on Article 41. Article 41 is, with your kind permission, say, the exercise and enjoyment of rights and freedoms is inseparable from the performance of duties and obligations, and accordingly, it shall be the duty of every citizen. And then the clause F says to protect and preserve public property and expose and combat misuse and waste of public funds and property. So you see, we have been given all kinds of freedoms under the 1992 Constitution. But the same Constitution says, yes, once you enjoy these freedoms, I'm also imposing on you as a citizen of Ghana
a duty.
Some duties. It is just one of the duties that Occupy Ghana has. You see, so for example, if you look at even Article 41, plus K. We even have a duty to protect and safeguard the environment. So when you see the dam sites and all those things, you can even bring an action against the relevant state authorities that they are destroying the environment and all the rest of that. Samson, going forward, I think that...
But the Attorney General was making the argument that there was no human rights as in personal that was being violated in the process, and that in the first place they didn't even make a request for the information. If they had made a request for the information,
they rejected.
And they had been rejected. But the judge had a very interesting thing to say.
Yes.
If you are saying that they ought to have made an application for the information first, why are you here challenging them that they shouldn't have it?
Fantastic.
When they served the process on you, you should have simply said, come for the information.
Yeah. And where the Attorney General was going would have been very, very, very germane if, for instance, we had the Right to Information Act and it has been spelled out there that before you go to court, you must first apply, and then if it is not forthcoming, then you can go to court. But in the interim, is the
constitutional... That's only a requirement for mandamus.
Yeah,
and that's on the purpose.
Yeah. So Samson, you see, I think a clear signal has been sent to, public bodies, government, the state itself, that forthwith, anybody, unless it's a national security, matter, or classified state secret, all that the person needs to do is to go to court. But I have a worry.
The judge is clear that no matter what the subject is, if there is the harm test that he went through, he went through the European Union and brought a whole lot of law.
Because most of our provisions related to that are from the European...
The test ought to be this. If the disclosure will cause a harm, which disclosure outweighs the public interest, then it will not be disclosed.
Yeah.
Right.
It's a very elastic, kind of situation that we have. But so all I'm saying is that let a signal clearly be sent now on the back of this judgment to everybody who is in public office. Or, we have come from a system where a minister of state has said before that when I enter my office and shut the door, whatever happens in there is private. You go back if you remember. Those were heady times in this country. Now, come 2016, we have this judgment. All I want to say is that, nevertheless, we need to get a Right to Information Act so that the strictures for this will be put out. Because when you say, for example, that all documents relating to the transaction, the government or the transport ministry can decide that, what do you know? You who is applying, what do you know? I can give you the contract. If there was let's say, an addendum to the contract, I can hide it from you. You wouldn't know. You understand? So there's also a certain duty on us as we seek, to go for these things that we need to know. Sometimes if you are well, list them. You understand? Rather than saying all, because all, if I look at my friend Mr. Metokwame, for example, assuming that in his professional capacity, such an order has been made against him, that come on, what went into this contract, he can decide that, he's doing cherry picking and give you what he thinks will be okay for you. So we also have a certain duty, to in going for these things, to also be very, 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 very exact. Oftentimes, you may even have the information, but if you put it out, they can say it is not official, and that kind of thing. So, let's as we go forward, also ensure that even before we go for these orders, we use our own methods to ferret these things and then go officially and test it against it and see whether what has been given us.
But more particularly, you with Occupy Ghana, you'll be excited that because this has happened, your way is a lot more clear with yours.
Oh, certainly. Certainly.
That brings me to the question. Of course, yours is not before the same court, it's before a different court. Which is also a high court, which is at liberty to take a different decision.
In fact, the courts are adjacent.
Yes, which is at liberty to take a different decision. Now, would you be surprised? In this court, I was a bit surprised that the Attorney General was opposing because I had the feeling that they may not have read even this judge before. This judge is widely publicized. He's got 2 books, one particularly Rights in Action. If you read that clearly, in American jurisprudence, you can predict a judge.
Yeah.
You would tell that this judge will take you to town, go to Europe, go everywhere, and come to the conclusion that this is a decision. And again, on the back of the fact that in the presidential election petition, the court had held and affirmed that Article 21 is the case, that individuals have the right to information, including access to the documents that are in government domain. Why do you think that state officials will oppose such process? Individuals asking for information.
Samson, first of all, when I saw that they had raised a plenary legal objection, I wasn't surprised because, as you know, our litigation system is adversarial. You understand? So once you have seized the jurisdiction of a court to enforce certain rights, it also lies, within the rights of the Attorney General to even come and ask about the capacity in which you are doing so and all that. Every good lawyer will do everything to frustrate your case. Not because necessarily he has something to hide, but if I can take you out on a technicality,
why not?
Why not? So that litigation does not stay on. So, I will not fault the Attorney General for the posturing that it had in court, because why? It's the beauty of the law. Once you have the right to sue, I also have the right to to bring a shield and prevent you from piercing, me and finding out what more. The Smartty's deal from. Let's take judicial notice of the fact that there has been a resignation, there has been a refund, so we know
a refund
that
initially was supposed
not done
to be 1.9 million, but was subsequently reduced after discussions with the Smarties to 1.5 million.
Yes, but that is why. But that is why.
And that's been fully paid.
Yeah,
but that is why this judgment. That's why this judgment is very, very welcome, because I think that discretionary powers were used in the award of the contract and all those things. Was it right? Once if Citizen Ghana gets, or Occupy Ghana also gets those documents, we'll look at it and we'll go after people who exercise certain discretionary, acts in.
Oh, so that's what you're looking forward to?
Not
to just end there.
No. But it cannot end there. It cannot end there. You see, people have exercised, public officers have exercised discretions in this country, and they keep doing so. As to whether it is right, proper, if some of those public officers were running their private businesses, would they have exercised that discretion? So there's a long battle ahead to test the rightness or wrongness of the use of discretionary powers by public officers in some of the public transactions that we've seen.
Okay. Now, the Right to Information Coalition has issued a statement on the back of this, hailing it and also asking Parliament that this shows that it is time to be speedy with the passage of the Right to Information law. The coalition is saying that they need to do this quickly because, for example, in this judgment, Citizen Ghana is being asked to pay a fee of 1,000 Ghana cedis to access the information, which information actually is photocopies of these documents that are going to be made to them. And if you look at the Right to Information bill, it would have cost them some nominal amounts.
How would they know?
Who know?
How would they know that it would have called them minimal?
How does the court arrive at the 1,000 Ghana cedis?
Yeah, well, that's the difference because the right thing, we haven't even gotten there yet. And but Parliament will take.
No, but if you pass it now, you are able to know that if you are going for this sort of document,
I agree.
They will know that it's a photocopy of how many pages.
What if Parliament comes? What if Parliament comes and says it should be 2,000?
Oh, Parliament cannot say that.
Why?
You cannot say that.
Why?
We are here in this country. We won't let you say that. I won't let you say it. You are not there to represent yourself. Now, Senator Kwame, I am looking at it this way again. As far as you are concerned, do you think that the Smartest deal, to the extent that the monies are being refunded, the overpriced part are being refunded, do we need to go through all of these things in seeking to know what exactly happened, whether there was a tendering process, whether there was a procurement process duly followed, and all of that?
You see, the people who went to court knowing very well that the government has taken certain steps to correct the anomalies or to arrest the anomalies that were in the contract once it became public knowledge and there was an outcry. One of them was that the Chief of Staff asked the Attorney General to look at the contract again and vet it. That was done. And they came out to say clearly that the contract was overpriced.
Yeah, because each bus was costing about 31,000 Ghana cedis, when some of those who had been involved in the contract had come out to say that they took only 1,500 or less, 1,200 or so.
Yeah.
Or 600, I think.
Yeah. But that was not all the job. Actually, so the government's position is that the contract was overpriced. Then they went ahead to say that let them refund to the state what do a little bit of due diligence. Go to the market, find out from other companies who would or which would have done this job, and find out comparative cost and take a decision. So the Attorney General suggests that they should refund a certain amount. The company then sits with the Attorney General to negotiate. And I believe they also brought, relevant information, which made the Attorney General scale down to the 1.5 million, which they have duly paid. So all these are public knowledge for those who have decided to take the issue to court. What they are asking now is that all documents relating to the transaction should be made available to them, which the court has agreed to. My questions are, what exactly do they want to achieve beyond this? And Egbert has been generous to let us into some of the intentions that they have. And when they say the matter will not end here, it means that they intend to take further action. If the information
there were
they
breaches
have
during the procurement,
exactly,
they will hold those people accountable.
Yeah. My thinking as a very lay person is that if you want to prosecute for something that has been done in a criminal domain, it's only the Attorney General who can go to court and prosecute. I'm yet to learn whether a private or an organization or a private citizen can then go to court and compel the Attorney General to prosecute. I'm saying I'm yet to learn.
Well, I hold that view, and I feel that somebody should test it.
If that can be the case,
judgment,
that somebody can do
it. The judge refers to an Australian decision in which, the Attorney General has the power to discontinue any case they are doing without giving any reason. And in Australia, it happened. And the judge referred to that case and said that, in that case, the individual who went to court said that they needed to know the reasons why the Attorney General was not interested in continuing with the case. And that was information that was crucial to the public, to not to erode public confidence in the judiciary. I hold the view, respectfully, that we should be able to go to court and say we know a crime has been committed by an individual and that the Attorney General should prosecute.
Samson, just not to cut you, but are you aware that the current Attorney General has lately adopted a position where when a nollie prosecutor is entered in a case, she issues a statement?
She's done it once.
Yes, once.
And she's been praised for it. She hasn't
explained why she entered a nollie prosecutor. And I think it is commendable. So from where you are going and from where Samson is coming from, I see a situation where what the Honorable Attorney General has done may be used as a basis by any court that it is reasonable for good governance and all, and to show that when you use your discretionary power, it was done according to certain reasons.
But will a court of law be able to compel her to give a reason?
Well,
that is
Article 296 also gives you instructions as to how to use discretionary power if you are not a judge or a judicial officer. So there's a foundational basis.
Yeah, but still, I have my difficulty. But again, it's for the court.
Okay, let him finish his point. And then when he's done, I will speak to Mina Mensah of the Right to Information Coalition, RTI Coalition, and then we'll hear Kokobako. Yes.
Proceeding from there, I believe that the position taken by government and Attorney General clearly is not to go to court on this matter. That's why they've taken the administrative decisions to let them refund. The discretion here is whether you should go to court and seek a conviction of the actions and the inactions and get the persons prosecuted. Or, in lieu of that, retrieve the difference, which will then inure to the benefit of the state. Hasn't the Attorney General got a discretion in this matter?
That discretion is actually supported by law, that she can ask for the refund and leave it there. Yeah.
Okay. So when people want to go to court and get the disclosure and then proceed from there, then I look at it around this and say, what exactly do they want to achieve? To get people punished?
Accountability.
Or to let the state benefit by the decisions that have been taken by government?
Okay. Maybe both ways.
Yeah. Now, again, myself being a professional in the area where information is the raw material by which we manufacture our products with the final news. You know, I'm happy about this ruling, that it will be much easier for a journalist to approach an institution to say that we need this information, and that it will be a little bit more easier and forthcoming.
It will not be that simple.
No, I'm saying that in the light of this ruling, it might be a little bit more easier and much more forthcoming for institutions to tacitly hold on to information and say, we will give it to you. And so, since, you know, rulings and judgments of this kind also have their own weight in becoming precedents on which the further decisions can be taken, I'm hoping that this ruling then opens the way for future actions, particularly for those who use information as the main source for doing what they do.
Okay, let's speak to Mina Mensah. Mina Mensah is the regional coordinator of the Africa office of the Commonwealth Human Rights Initiative, and she's with the RTI coalition. That's the Right to Information. They have been at this crusade from the very beginning. In fact, the RTI has become synonymous to the coalition has become synonymous to the law itself. They are the ones who pioneered the amendments that have all been put on it and which are being debated now in Parliament. Okay, I understand that. Okay, thank you very much, Mina, for joining us on the show. Hello.
Hi, Samson. Good afternoon. I can barely hear you.
Okay. Can you hear me now? You issued a statement, and in the statement you have hailed this particular judgment and used the opportunity to ask Parliament to fast-track the process of passing the RTI law. Why?
Thank you very much once again, Samson, and good afternoon to your panelists and listeners. We did that because immediately the statement came out, a lot of information going out was like, okay, because of judgment, we don't necessarily need the law, and that Parliament could take its time. But I think that in the light of this judgment, the onus lies on Parliament to even speed up the process. Because yes, a law has been, a judgment has been given, but there are certain modalities that a right to information law would give to citizens. Like I said a couple of days ago, yes, you can go to court, but at the end of the day, the right to information law is not necessarily for only the elite, but it's also for the common person, for the grassroots person. How many people can go to court to enforce a constitutional right? The right to information simplifies things. It actually gives out modalities and also ensures that there's a way, an administrative way of ensuring that if you are denied information, you can have redress. So that is why we issued the statement. And also because as much as the judge was very extensive in his judgment, there are certain issues that needed to be clarified. So that is why. And we think that Parliament has started the consideration stage, but we are in an election year, and the way this bill has been back and forth and taking so long, it was time for us to remind Parliament that passing the law should be one of their priorities. So that is why we issued the statement.
I see. You are saying they should be fast about it, but you know that they just recently started the process. So why asking them to be fast about it again?
They recently started the process. That's, I think, a month or so ago. It was one clause that was raised. A lengthy discussion went on about that particular clause. And after that, we haven't heard anything about it. So, and no information whatsoever. So, obviously, it's a cause for worry for us, because we were expecting that if one clause has been discussed, subsequently, if 8 other clauses are picked, then we know we are going somewhere. But one clause, and after it, nothing else. So we needed to at least make a comment on that score, because it has been the process. During the second reading, it took a very long time before it was concluded. So that is why we raised that issue again.
Right. And you make a point in your statement that, again, you seem to have a little issue with the fees that they were being asked to pay, for example, 1,000 Ghana cedis. You think that's on the high side?
Exactly. We think that's on the high side. Because at the end of the day, how many pages is that? And if, let's say, it's even about 20 pages, every cost for that information to be photocopied. The idea behind the right information law is to make it as easy as possible for people to access information. So if you are saying that people should pay 1,000 for accessing that kind of information, how many people can do that? It's a deterrent. We thought that it could be that the judge would ask that they will pay for reproducing the information that is needed. That we felt would be more reasonable than saying that they should pay 1,000 Ghana cedis.
Okay. So going forward, you're celebrating the judgment in your statement, but are you going to take any further steps to get the MPs? And the one MP here on the legal and constitutional affairs is right here in the studio. Are you going to go beyond just making the statement to get them to be fast about it, so that, because as it is, if anybody goes to any place to ask for information, it is on the goodwill of the whoever is supposed to supply the information to give it. If they don't give it, the individual has to go to court again. And like you said, not everybody can afford to go to court. And another aspect about it is that we are going to court over public institutions that are refusing to give information. But when the law is passed, it will not be limited to only public institutions, but also institutions that are not public but are dealing with public institutions.
Exactly, because the right information law, or the bill, seeks to cover public institutions or private institutions that perform public functions.
Right.
Apart from that, we are engaging with Parliament. We are still talking. And the conversation is quite favorable, but it's one thing to talk, it's one thing to make promises, and another thing to deliver. So yes, we are extremely happy with this judgment. I mean, it's a plus. It actually buttresses what we've always said. But we are still engaging with Parliament, and we are hoping that they will see where we are coming from and fast track the passage.
Thank you very much, Mina Mensah of the Right to Information Coalition. Now, let's hear Abdul Malik, and then we'll go on a break and come back to see if we can deal briefly with the issues of validation and the EC dealing with a logo that is getting the attention of too many people. And now the logo has been turned into a wheel of fortune. You should follow social media. They've redesigned the logo into a wheel of fortune. And, you know, there are colors in there. If it falls on the white, then it means the MPP will win. If it falls on the green, then it means the NDC will win. If it is yellow, then it is it PNC or so?
I see.
You haven't seen it.
That's what we have reached now.
Yes, that's where we are.
Okay. Based on what the interview you just had,
right?
Something struck me. You see, this agitation, crusade for the passage of the Freedom of Information Act,
right,
It's worrying why, as a nation, we've handled it the way we've had. Look, the agitation predated the advent of the Kufuor administration in 2001. If you go back, throughout the Kufuor administration, the agitation continued, and it's continued to today. Let me just give you a typical thing that illustrates how we go about things. This is a statement that Kobna Japan issued 12 January 2004. And in there, he talks about the repeal of the criminal libel law and the imminent passage of the Freedom of Information Act. This is 14 years ago. Imminent passage. Obviously, apparently, this did not even leave the cabinet. It stayed with cabinet. So post 2008. Fortunately, we are told it's now in parliament. So you can see the number of years. Cobra made this statement 14 years ago. But before then, we had been agitating. And I thought, when the criminal libel regime was repealed, I thought it was going to serve as a momentum for us to move towards this in terms of the democratization exercise. Unfortunately, it didn't happen. So I'm in full support of those who are agitating for a fast-track approach. Having said that, let me join Egbert in.
The judge said one thing, that the failure of the state to pass this law does not give them the right to benefit from that failure.
I agree.
Because we were trying to say, even if you have to come, you may have to come by information, you know, a Right to Information Act. And the judge said, you haven't passed it. How long now? So don't come and benefit. You won't benefit from it.
Unfortunately, we have Article 20, is it 21F?
1F.
In there. So it gave us the impetus to move on. So I must congratulate the civil society organization, Citizen Ghana movement, Occupy Ghana also pursuing. This just vindicates the Transparency International report, the latest one, that pointed to the civil society activism as a way of expanding our freedoms and fighting corruption and all the rest. This is also part of the fight against corruption. You know? So it's good, really. But did government have to wait for this to happen to them? You recall some of us made a point that, look, after the Chief of Staff having directed the Attorney General to probe, and Attorney General having conducted a probe and presented a report, a Minister of State had exited, that is resigned. Attorney General takes directives from Chief of Staff, obviously working under the instruction of the President, conducts a probe, a report on the probe is submitted, and we say, publish it. What do you lose, government? To show. Amete Kwame was asking, what's the purpose? If you read this constitution, before the Fourth Republic, we had freedom and justice alone as part of the cardinal principles. Now we have added to it probity and accountability, which actually came about through blood, tears, and sweat. So now, instead of freedom and justice, we have freedom, justice, probity, and accountability. And government failed or refused
to publish. Not too long ago, what is his name? The Ama Kofi Boa, on their Mary issue or one other issue. I think Occupy Ghana went for the information and he supplied them the information. When he supplied the information, Kwabna Donko, he supplied them the information, and some people in government and the party criticized him for doing so.
That's subculture, you know. But even in this case, Occupy Ghana wrote to the ministry. Is it the Attorney General, rather?
Yes, they did.
And they said, oh, because the case is pending in court, we can't disclose the documents.
Right.
As if in court, those documents were not going to be made available as part of your defense.
Right.
And then again, I'm saying that thing didn't help government. Now you are going to have to do a full disclosure relative to the relief sought based on a court order. Needless, avoidable. It doesn't help government in terms of the provision of leadership of integrity. It creates the impression as if there was something to be hidden. People have engaged in a transaction not in accordance with law. Your own report showed it. And you know, there was this controversy as to whether the leakage, some leaked portions were authentic or not authentic. Now, whether you like it or not, you've got to bring the report. And make sure you don't do a page 28.
Have you seen the report?
You asking me? I'm waiting till they do a page 28.
We have seen portions that have been denied.
I am waiting till there's evidence of a page 28.
Okay. The one you have is not correct.
That's what my worry
You
is.
see what he just said?
Okay, so
that's it. I mean, I don't think we should belabor the point, but kudos to Citizen Ghana movement and the Occupy Ghana and all the other civil societies.
Okay.
This is the only way we can expand our freedoms and rights.
thank you very much. And you just referred to you don't want a situation of a page 28. My production just drew my attention the need to actually have explained the nolli prosequi. Page 28, what does that mean?
Oh, have you forgotten? Egbert can tell you the story.
I'm sure there are many people who remember.
There was a judgment.
Page 28
there was something
of a judgment
that
got
was
missing.
Yes, there was a judgment and then a page 28 relation.
They changed it.
It was changed, the typeface and all those. It's a reported case, actually.
Thank you.
Indeed, Justice Logo.
Yeah.
No, the one, yes, but I'm talking of the one in the Anas case.
Right.
Is it Logo?
He was.
He was involved in.
Right. Thank you. We have mentioned it here before. Sure. Anyway. Okay. So here's where we take a break. And when we return, we'll see if we can deal with the EC briefly. As we speak, I think Citizen Ghana still has another rate in which, another process in court in which they are seeking more information on Ameri. I'm thinking to avoid the court processes, just give the documents to them. If they are not state secrets.
What's that one? This one too is also going to come up. Is it blue, whatever? Is it
West
blue?
Okay, West Blue. Okay.
Yes, that one too is going to
Right. Thank you very much.
Yeah.
Right. We'll be right back.
I forgot your test.